Big story of the hour. In a major update in the Twisha Sharma death case, the CBI has now filed a 636-page charge sheet before the special CBI court in Bhopal, naming husband Samarth Singh and mother-in-law, former judge Giribala Singh, as accused. Both have been booked under serious sections of the Bharatiya Nyaya Sanhita, including dowry death, cruelty by a husband or relative, and abetment to suicide, along with charges under the Dowry Prohibition Act. This comes after both accused spent over 70 days in CBI custody following a nearly 3-month-long investigation involving forensic analysis, digital evidence and a court-ordered second post-mortem. But while the charges are serious, CBI's own findings reportedly lean towards suicide, not a murder, a sharp contrast to family's original allegations. The court has now summoned officials again today as the process moves forward. The next big question, will the court take cognizance of what happens to the bail pleas already filed by both the accused? Let's start our conversation. Brinda Adige on the telecast with me. Brinda, what do you make of these fresh revelations after the charge sheet that has been filed by the CBI and the final forensic opinion that has been released by the AIIMS Medical Board?
After everything that the two, mother and son, did to wipe away all evidence, to ensure that they keep everything clean, and they had so much of support from the police, so much of connivance also with the courts, they should have been booked for murder. The forensic evidence should have pointed out to all of that, but whatever they did, now abetment to suicide is such a light, very light sections that has been added by police. Because you and I know that the girl spoke to the parents just a couple of minutes before she died. So there was no, there was not a mindset that she was going to commit suicide. She was asking them to take her back home, which means there was this sense of her being ready and waiting to be taken back home. There was nothing that was talking about her being in a situation where she is going to take her life. So probably all of them have connived again, the state agencies, to just say, okay, let's give you the lighter part of it. We'll just put down over the abetment to suicide, because otherwise we have to be now going around getting the evidence.
Yeah, but after repeated pleas, the family went to the Chief Minister's residence. He assured them the case is going to be transferred to the CBI. Even though there had been a lot of lapses, as you said, there had been connivance at the part of the police and Giribala Singh and her son. The son had been absconding for several days after this incident took place. The mother-in-law was in fact given an anticipatory bail already, even before the case was filed in the police station. At this time, I do want to bring in Juhi Arora. She is Advocate Supreme Court. Juhi, let's hear it from you with regards to what is the kind of punishment that the mother and son are likely to get in an abetment to suicide case.
Hello.
Can you hear us, Juhi? Yes, you are. Please go ahead.
Yeah. See, kind of charge sheet which we are seeing now, it is a kind of a shock which is there, because we all were looking forward to have at least offences which they have committed. Because it was completely before everybody that they have done this kind of an offence. But charge sheet has been broke because of the abetment, rather than of the murder. So it is a shocking by itself, and as far as the abetment is concerned, abetment to suicide, so we can see that in these kinds of offences also we can expect the imprisonment for 10 years, we can extend it to 10 years also. But as far as the murder is concerned, there we can expect for life imprisonment also. But in these kinds of offences with regards to the abetment to suicide, we can't expect to get a sentence of an imprisonment of life.
Yeah, but you think in the court hearing, when the judges presented the case, this girl has obviously killed herself because of the kind of mental and physical torture that she was facing at the hands of the husband and the mother-in-law, would persuade the courts to pass the stringent punishment against the two?
See, actually, what happens when we talk about the kind of investigation when anybody does, they have to take inclusive of all the materials which has been there on record, and they have gone through the forensics. They have gone through the trial of again. They have reconstructed the same crime scene at the time when at the same place where she was hanged. So by doing all these, still they have not got them booked with the murder. It might be they have not got any direct forensic evidence to that respect, or maybe the direct connection to that particular offense. That is why they are. I believe that is why CBI must have not filed a charge sheet with regards to
So do you think at
this
this point in
offense.
time our enforcement agencies, the CBI's hands are tied because you have to work in the realm of the existing laws? And do you at this point in time feel that there need to be changes that need to be brought in, amendments that need to be brought in for more stringent laws to be put in place? There have been so many cases, hundreds and thousands of cases across the country where women have had killed themselves, they have committed suicide, and it has only been for the sole reason that they were pressured, they were physically abused, they were mentally abused by the in-laws.
See, laws are already existing, and we have to be very much set a precedent. Now it's high
No, but
time
then
for
you at this point in time are very clearly saying that simply because they were actually not present when, they actually did not commit the murder, but because they pressured the girl to kill herself, therefore as per the law, you can only be charged for abetment to suicide, to abetment to murder, and the Dowry Prohibition Act on which they have been charged.
Yeah, I totally agree to that extent. But in that case, they have to we have to see so many parameters why they have got it booked. Maybe the state case will gonna object to that case. Maybe this will gonna come in the trial that what state would be pointing out the objection that why these they might be going ahead with the arguments that some other charges should be added in this charge sheet, or maybe sometimes the CBI can file supplementary charge sheet to that effect also.
Okay.
But it totally at this point of stage, it has really come as a shock to all of us that why he has only booked in these kind of offenses, not rather than the murder and all.
Sanjay, I get into the conversation over here. You have been in the police forces. How do you read the situation where the CBI has taken over the case as per the forensic reports of the AIMS Medical Board, which has once again, done the post-mortem of the body and concluded that it was in fact a suicide. It was not a murder that was committed by the son and the mother-in-law?
The AIMS medical report, I think it was submitted in a sealed cover, and we don't know the exact details of it. But given the fact that the case was charge sheeted for dowry death, abetment of suicide, harassment, common intention, and for dowry prohibition. So what you people have been talking about is the abetment to suicide. So that is the minor section in this charge sheet. The major section in this charge sheet is section 82. And 82 is dowry death, which happens in less than 7 years of marriage. Any death of a married woman which happens in less than 7 years is treated as a dowry death. The punishment for dowry death is imprisonment for not less than 7 years, which may extend up to imprisonment for life. So I think there is sufficient leeway today also that if the case is carried through in the manner it should, and if the investigation which CBI has done is not full of internal contradictions, and if they're able to get a good prosecutor and they get a conviction for life imprisonment for dowry death, I think we would have reached some goal as far as this particular case is concerned. This case is more known for the nature of laxity with the police and the government and various other agencies, and how brittle and broken our system is, that it can be influenced in a manner it was, from the registration of the case to the post-mortem, to I think 40 calls being made by this lady, and then we also had press conferences and variety of other things, which literally talks of a broken system end to end, and not only the investigation part of it. So what is actually important to the current point in time, which I'm really bothered about, that CBI hopefully he has done a very neat job and will basically feel best of the prosecutors possible. So I think that like Ujjwal Nikam, somebody who can take it through. My
Okay.
understanding is that one line. My understanding is that based on whatever investigation done so far, I think they have taken very careful and meticulous understanding of things, got the evidence in place, stitched it together, and they should have created a case, or they have created a case. Let's see how it opens in the judicial trial, where it should become a complete close and shared case, given the nature of evidence that is available
Okay, all right,
today,
all
mostly
right.
by way of digital
Yeah,
evidence.
okay. I am right now be joined by Navnidhi Sharma. He is the father of Twisha Sharma. Navnidhi Sharma, your first reaction to the charge sheet that has been filed by the CBI against the mother-in-law Giribala and her son Samarth.
Sharji, see, if I look at as a whole, the charge sheet, is not that satisfactory because it is not answering any of our, not addressing any of our query. It looks a kind of a casual approach towards a case where partial charge sheet has been submitted and things are not framed in a conclusive manner. The charges of dowry they have kept open and other charges of course, but you see that all the FSL reports are awaited, vital FSL reports are awaited, other findings are awaited. So still it is very very much open because it's a partial kind of a charge sheet, and they have not addressed any single query, any single answer to our questions which we raised since beginning. If you see the chronology of the case from the beginning, there were a lot of issues. Why they have not called police, ambulance, they have not taken the photograph, they have not called us, video call has not been shown. Lot of things which has happened till now, and there was a tampering of evidence, DVR. They have called 46 people, including that CCTV fellow, and the person sent the legal team to this beauty parlor, and that person was absconding. His own son was absconding for more than 10 days. What was the reason? What was the reason? Or he was not medically examined, not examined for drugs, not examined for the DNA traces. What is this? All the circumstances, evidence, they were indicating something different, and this influence is quite evident from the PM2 report, which we have received now.
The AIMS medical opinion in the forensic report also mentions that the death of the girl
they are contradicting their own
the death of the
family.
girl is in all likelihood suicide, and it is not a
because they are
murder that has
contradicting
been
their own
committed.
family. It was mentioned in the first PM that the antemortem injuries. There was a clear-cut mention of the antemortem injuries, and they have made it into the pre-mortem injuries. I want to ask, can you make a mark on dead body? No, it is not possible because blood becomes liquid. It does not leave any mark on the body. Here are the mark of blood clot. Here are the mark of blood clot quite evident.
Okay. Also,
There are
are you
so many things. There are so many things. We will definitely, because they are contradicting their own people, their own branch, their own family. There has to be a panel when a forensic, any PM postmortem is done. There are some basic rules. We were raising from beginning that belt ligature was not submitted during first PM. Why the second team did the PM2 without ligature again? There are a lot of questions which we need to satisfy.
at this point of time, are you trustful of the CBI following protocol and doing its job honestly?
I actually Look, the expectation from CBI is on a higher side. It's a premium agency of the country. And this is not a case of Twisha. This is a case, this is the hope of each and every girl who is, looking forward for this justice of Twisha, because they have lost the faith in our criminal justice system. All want, everybody is looking forward for this case, so there has to be, the challenges has to be taken very seriously, and through the charge sheet it is looking that the approach is quite casual.
What is it that you want to demand from the government,
We
from the
demanded, we
Madhya Pradesh
demanded,
Chief
we raised the
Minister?
queries, we have certain queries. You need to, satisfy us. You need to, there are circumstances, evidence, which, we need solution for that. We need answer for that. We raise these questions.
If
We
not
raise
the
these queries.
CBI, who would you like the case to? Who would you like
No,
the
no,
case to be handled
so
by?
we don't have this. That's why this criminal justice system need to be, changed. We are not now, forced to be in our hand. We can't do anything. We can't do anything. Nothing is in our hand. Nothing is in the hand of a victim. Though
Now
we
that
will
the
look
case is
forward,
going to be heard in the court,
the court,
and there's a charge sheet
because
that has been leveled
yeah,
against the culprits.
let's see. It's a beginning. It's a the beginning. We will protest for what we require, and we will fight for that till our, last breath. We will fight for that, and we will fight for a justice, because this is not the only Tusha case. This is a case which other, whole society, whole India is looking forward for this justice to, come into surface.
Do you, in the past several cases in our country that have happened across time, hundreds and thousands of girls killing themselves or being killed due to dowry deaths, pressure, the kind of abuse they face, mental and physical, from their in-laws. Have there been cases
Because
where there
we
has
have
been an
not done
example
any reform
set
in our
and
criminal
strong
justice
action
system.
taken against the murderers?
Yes, we have not done any reform. Immediate reforms are required. Immediate things are required. So that is the case. That is the case. That's why we are looking for certain answers. They need to answer. Why he was absconding? Why the call were made? Why the influence? Where the influence? Why that policeman was carrying the belt for 3 days in his car? No answer for our genuine queries. They have not addressed.
Navniti Sharma, thank you very much for speaking to us on NewsX, and more courage to you. Now that the charge sheet has been filed, the forensic opinion of AIIMS Medical Board has also been released. The case is going to be heard in the courts.
Yeah.
And we'll be very closely monitoring that as well.
Thank you very much, madam. Thank you very much.
So that was
Yes.
Navniti Sharma, Twisha Sharma's father, speaking to us exclusively. Brinda Adige back on the telecast. Brinda, you've heard what Navniti said. What's your reaction?
I agree with everything that he said, because the CBI cannot ever say that they do not have evidence. The post-mortem was done the second time after the courts intervened. So the state agencies, the police, the prosecution, and the judiciary connived before, and they have connived again now to ensure that Giribala Singh and her son, who was absconding right after the murder, are not being questioned. The CBI is probably scared to ask those very, very pertinent questions as to why haven't you looked deeply into the marks that are there on the body? The post-mortem autopsy reports are very, very clear. So why are you not taking that into cognizance? Why is it not put on your charge sheet? At least you can say, yes, there was murder. Maybe these two didn't commit the murder. You can put it down. And then maybe later on you can talk about saying, why would you say that these two didn't do it? This is a clear case of murder.
Do you think
This
because
girl
of
did not
the
commit
position
suicide.
that Giribala Singh at one point of time held, which is she's been a former judge, she may have the kind of influence that could be used in this case to save herself and her child, her son?
Absolutely. When she is holding a position, a government position after retirement as a judge, she still holds a lot of clout and influence, probably a lot of favors that she called for. Irrespective of what anybody wants to say, we know that there is a lot of these kind of favors that are done by some of the judges in all courts. And so once their retirement is over, they have retired from the service. Even now she was holding a government position until all the media went up in arms to say that she can't hold that position. So she is calling in favors, and she has called in favors, and the CBI is scared to actually name both of them as murderers, even though all your evidence points towards it. So they are now putting a very, very light charge sheet over there saying abetment to murder, abetment
Okay.
to suicide.
Okay.
When you and I know that there is nothing that points to suicide. Giribala Singh and her son washed the entire house before the police came. They even tried to, take away the CCTV cameras. They tried to fudge some of those other evidence that she thought might be used against her and her son. So she is a total culprit along with her son.
Okay. All right.
Abetment to suicide is very light.
Okay. Brinda, thank you very much for speaking to us, and I thank all my other panelists also for joining us on the telecast and discussing this important development. On that note, I slip into a short break. Thanks for watching NewsX.